The Mountain West's motion to dismiss is denied.
Lawsuits and realignment are always in the news, so we're back on the Big Mountain with an update.
Hey, welcome back to the Big Mountain. JY with his good friend Steve. We have another lawsuit item to talk about. We've done a lot of that since the beginning of this channel. This being, of course, the Pac-12 and the Mountain West. There was a written ruling that was released or issued on September 30th from the judge regarding the motion to dismiss, and this was dismissed in total. So the case is going to be moving forward. I don't want to get into a whole lot of detail in this. I mean, we have talked about what the counts have been before. We talked about what the Mountain West has said before. You can check out our channel if you're interested in knowing more about the actual lawsuit. I am going to focus here just on the dismissal and what the judge actually said in her written ruling. I think it was about 15 pages, give or take, something like that. First, the judge lays out what is required by a plaintiff, and the plaintiff here is the Pac-12. They're the one bringing this lawsuit against the Mountain West in terms of a claim or counts against another party. The plaintiff must allege enough facts to actually state a claim or an unlawful act in this case that is plausible on its face. The court must accept the allegations by the plaintiff as true and draw all reasonable inferences in the plaintiff's favor. So I want to make sure that's really clear before we go any further. I have two important parts on that. Number one, that things are plausible, counts are plausible on their face. Plausible means, it's a fair claim. It's reasonable that it could have happened or could happen. Also, it could be deceptive. I mean, plausible could also mean that there's deceptive things going on. But in this case, it pretty much means, okay, they made a reasonable attempt at a claim here. And it's, worthy to believe, again, on face value. Also, as I said, all inferences in the case must be given to the plaintiff. So, if it's kind of maybe murky, if it's kind of gray, all inferences have to be given then to the plaintiff here. So the odds are very clear that, dismissals, and we see this very often, dismissals are very, very rare. They don't happen very often. And so, that's basically what these two things mean, that, the plaintiffs really are given the benefit of the doubt, to put it in layman's terms like we are, the benefit of the doubt to bring these claims and then to move forward with the trial. Now, I want to summarize the judge's ruling here pretty briefly, and then Steve, I'd love to hear what you have to say about this. So there were 4 counts, again, that we talked about many times. She stated that she found it most prudent to better ascertain the substance of the parties' arguments, both parties' arguments, based on a more complete factual record, basically meaning a trial. She wants us to go to trial to get a more factual record from both sides on all the counts. She said that repeatedly throughout this finding or ruling or whatever you want to call this from the judge. Regarding the antitrust claim, which to really 3 of the 4 were surrounding this antitrust type of anti-competitive type of nature, she states that both sides try to fit this case into existing categories. They both kind of, both the lawsuit and then the Mountain West rebuttal, if you will, or response, they both try to fit this case into known existing past cases. She says, however, and we've said this before, Steve, the termination fees provision and the scheduling agreement have unique attributes that don't precisely align with the cases that both of the parties here had cited. So again, I have called this a novel case, a novel agreement. That she didn't use that word that I saw in this, but that's basically what she's saying there. She then goes on to state that the court finds it neither appropriate nor necessary to dismiss the antitrust claims in whole or in part on arguably inadequate pleadings regarding the defensive rule of reason theory. Again, just saying she doesn't have enough information. She wants to hear more from both sides. Regarding the 4th claim, this unenforceability of the liquidated damages or these payments that are due according to the Mountain West, she states that basing a determination on partial factual records would be premature. So yes, I'm being repetitive because that's the drum that she continued to beat. The judge now has scheduled an initial case management hearing on November 18th, and then there'll be a joint case management statement from the two sides due a week prior on November 10th. So we got about a month and a half until they're back in court in front of this judge, Steve. So I kind of laid it out. Opinions. What are you thinking?
Yeah, I not really surprised that much. We talked about this in another episode before, and a lot of these things early in the case, especially motions to dismiss, they're kind of Hail Mary attempts. Let's try and just knock this down before we even have to get into a trial. Yeah. And we call it some of these some Hail Mary attempts. So it is what it is. I'm not surprised. I did see there were some people that were surprised because I think was there 13 total parts to this. I think there was.
Well, there's 4 total counts. I'm not sure what
okay.
they would have meant by 13.
Well, I think some people I saw were surprised that maybe at least like one thing didn't get dismissed. That all of it went through. So whatever, but I thought overall, this was kind of a Hail Mary attempt and that we would get past this anyways to the point where either we get to a trial or this fails and maybe it brings us closer to settlement again. Who knows? One thing that did kind of surprise me, with her wanting to move forward towards a trial and get the information there, in contrast to what we saw down in was it Leon County in Florida, where the judge, was it Judge Cooper down there?
Oh, I don't even remember.
Yeah, I can't remember either.
Yes, it could have been.
He wanted them to kind of flesh out the arguments in the initial phase, during the motion to dismiss, and get a lot of their arguments, have them bring up facts and things really early. He wanted to get, was kind of arguing with them over different things.
That's true.
Where this judge is just like, nah, I wanted this to move forward. I want to get to the facts later of the case.
Yeah.
And there's enough here that they're obviously plausible claims, and I want to move forward and get to all that evidence and arguments and stuff later in a trial. So that was the only thing, just kind of her approach in comparison to what we've seen in other cases. But other than that, it wasn't that much of a surprise. I think that I was expecting this, and I think most people probably were as well.
Yeah, I mean, and I'll be honest, I put my marker on a partial dismissal. I don't know anybody that thought this whole thing was going to be dismissed.
Right.
I did not see that from anyone. There's a lot of people cheering this after the fact, saying, "Oh, they were all wrong. They thought it was going to be dismissed." I have not seen anyone say that. I did say I thought there could be a partial dismissal on counts 1, 2, and 3 regarding the antitrust claims. And here she's just saying, hey, there was a plausible claim made, and I need to hear more. Yeah. You can't really take anything out of that. She just wants to hear more. And she even, I should say, the Mountain West said in their oral arguments, and she noted this, against one of the claims that they said, we know that it's rare right now to dismiss this, but it's not unheard of. So everybody knows. The judge knows. The lawyers know. Everybody knows it's rare, but this is still kind of the common practice. You go for that dismissal. You try to maybe get some of this thrown out. Not a huge deal, in my opinion, that it's not. I mean, yes, I said I would be a partial, and it's not a partial, so I guess I got that wrong, but there was a guess on my part. And I actually appreciate she's saying some of the things that you and I have said and seen over the course of time with all of this stuff. This is a novel agreement. I mean, that's basically what she said. We've been saying that from the get-go. Yep. I'm not surprised that she needs to get into this more because, as she said, the cases that have cited on both sides don't line up with this exactly, and none of them will. So...
Yeah, and I think, and that's kind of where I was getting at when you said you thought there would be a partial dismissal.
Yeah.
That was the only kind of surprise that I saw, on Twitter, just reading different reporters and people. That was, a lot of people were expecting at least something to be dismissed, but not a full dismissal. And then another thought, like you said, very new, very novel, very unique case. I really, and I've been following college football closely since probably like the late 80s. And we've seen a lot of conference realignment, teams moving, programs moving, and we've seen those lawsuits where the school is suing a conference or a conference is suing a school.
Right.
But I don't remember ever seeing anything like this where schools come to an agreement that they're not going to poach, or not schools, conferences come to an agreement they're not going to poach each other, they're going to help each other do this or do that, and then end up suing each other because it doesn't go as planned. I don't remember, and I've looked everything I could find, and I don't remember ever seeing anything like this. So definitely, unique and novel. And we'll see. That the interesting part is, do we get to an actual trial where they start to make arguments?
Right.
Because this is so new and interesting.
Right. For sure. And I just want to make sure we say this is only the PAC-12's lawsuit regarding the poaching penalties in the scheduling agreement. This has nothing to do with the exit fee lawsuit of the departing members. Two totally separate lawsuits. I feel like I need to say that both times to make sure everybody's, kind of on the same page with all of that. So, hey, we'll make sure we follows this. November, we may get some more news. These are not broadcast.
Right.
So, you're not going to get anything from that oral argument here in about a month and a half. But we'll follow it as news comes out. And with that, hey, we thank you guys for watching this episode. Make sure you smash that like button, follow us, subscribe to us if you like our content, and we'll see you next time on The Big Mountain.